All set, Mike.
Okay, good morning. Welcome. I'd like to call the meeting to order. It is 9 o'clock. Stephanie, would you please take attendance?
Of course, good morning. Ava Bermuda Zimmerman has not yet joined us. Ellen McKitterick,
Present.
Alice Pritchard,
Here.
Mike Soltis,
Here?
and Holly Williams.
Here.
All right, we have a quorum.
Okay, thank you, Stephanie. I'd like to welcome and thank the members of the public for joining us this morning. First agenda item is to review the meeting minutes of September 5th, 2023. And I'd ask for a motion to approve those minutes.
So moved. Second.
All in favor?
Aye. Aye.
Any opposed? Any abstentions? And the motion carries. Thank you. Michael, would you please provide us with an update on the finance accounting manual revisions?
Absolutely. Thank you. And good morning, everybody. As the committee may remember, 2 months ago at the full board meeting, we had voted to post for notice and comment a couple of revisions to a couple of policies. One of those policies was the finance and accounting policies. These were mostly sort of clarifications, correction of job titles, some changes related to making sure we are aligned with signatory authority. Wasn't too substantive, just sort of making sure we were on the right page. Those policy revisions were posted in the Connecticut Law Journal for a 30-day period that closed on September 22nd. We received, I believe, one request for a copy of the revisions, but no comments or questions from the public on them. So the goal would be to hopefully share that with the full board next Thursday's board meeting, and then a vote to officially adopt the revisions to those policies. So not much there, but happy to take any questions that the committee may have about the revisions.
All right, any questions or comments for Michael on the finance accounting manual revisions? Okay, terrific. Thanks, Michael. Why don't you continue with private plan policy revisions? Absolutely.
So similar to the finance and accounting policies, we had made revisions to our private plan policies. Similarly, they weren't too substantive. It was mostly clarifications and limiting some extra information that's no longer applicable. But there were a couple of substantive changes. We did receive a few requests from the public for copies of the revisions, and then we did receive a few comments and questions from the public. So I would like to walk through those comments and questions with the full committee. And once again, the goal would be to share the revisions with the full board next week at the board meeting for official adoption. So I'm going to share my screen. And can folks see a spreadsheet?
Your screen.
Okay, perfect. So just a quick overview of what the spreadsheet is. This is a section of the existing policies that the comment came from. This is the language that was in the policies that they're commenting on. This is the comment or question from the public. This is sort of the authority's thoughts or response to that comment or question. And then this is the actual updated language that's responding to the or reacting to the comment or question. So I'm going to go through each one fairly quickly, but obviously stop me if you want to talk about anything or have any questions at all. I'm going to do the first two together. They're sort of related. This was a new requirement that we put in our policies that essentially said that employers shall provide employees with a copy of the policy showing the Connecticut paid leave private plan coverage no later than 60 days from the effective date of coverage. Essentially, so that employees will have a copy of the policy available to them within a 2-month period after the coverage starts. The comment or question from the public was that the employee already has sufficient information from the plain language guide. This is an expanded obligation for private plans. It would be unnecessary and exceeds existing obligations. It also changes the timing of the documents when they need to be provided, and it's duplicative because they already received it as part of the employee vote along with the plain language guide. It may be confusing to give it to them again, and at a minimum, it should be made clear that providing it as part of the employee vote fulfills the obligation, and carriers have built in the policy language that the employees have the right to examine the policy within the contract. We understand that it is a requirement that sort of carriers will have to turn around and create a policy relatively quickly, or especially compared to not having a requirement in the past, within 2 months of the effective date of coverage. However, we do think it is important that employees do receive a copy of the actual policy or certificate that's going to provide them coverage. That is the legal contract that is going to be used to adjudicate claims. Potentially, if there's any sort of litigation or dispute about a claim decision, it's that actual policy that's going to be important. So we do think it's important that employees have a copy of that and the actual policy. These policies are approved for a 3-year period, a 36-month period. That's what the typical exemption is. We're willing to push that requirement out to 90 days in deference to the carriers, but we don't want to go any longer than that, because 3 months of the 36 months that the coverage is enforced to not have the policy document available to you as an employee does feel like, kind of the edge of how long is reasonable for them to not have it. Any claims within that 3-month period, it would be nice to have the plan document to tell them what their rights and responsibilities are. So we're willing to push it from 60 days to 90 days, but we don't want to go any further than that. We did update the language to say that it's make available as opposed to providing a specific copy, so they don't have to have a physical copy handed to them or even emailed to them, as long as available to them within the 90 days. That's sufficient. And to the point about them having provided it during the vote, if they did provide the actual policy during the vote, prior to the vote, that's acceptable. They don't need to provide it again. But most employers are providing a sample or draft version because the full version is not ready yet. And that sample or draft may have sort of gaps in it, or language is not quite locked down. So while we allow it during the vote, we would like the actual contract to be available. So we made the change to 90 days, added language to clarify that if they already provided the actual policy during the vote or prior to the vote, they don't need to do it again. But if it was only a sample or draft version, then they must have the enforced policy within the 90 days. I'll stop for questions after the next one. I'll just kind of go to the next one as well, because it's related. Essentially, the comment's the exact same comment, just referred to the prior one. The difference on this one is we also wanted to add a requirement that employers upload a copy of that policy to their CTPL account as proof of coverage. So we essentially are saying that the employer has 90 days to provide that policy to their employees, and then they have an additional 30 days after that to provide it to the authority as proof that coverage is in force. Similar to the above, if they already provided it during the application process, they don't need to do so again. That's fine. But if they only provide a sample or draft, that is not sufficient proof of coverage. And also for fully insured policies, they don't have to do the whole policy. They can upload just the face page as proof of coverage. We don't need to see the whole thing at this time. So I'll pause right there. Does that make sense? Any questions or comments about those changes or the policy in general? Okay, I'll take silence as we're okay.
Yep.
Perfect, thank you. The next item is about a requirement related to the employer contact in their Connecticut paid leave portal. This theoretically should be done for any employers who are registered with us, but we particularly find it important for private plans because there's more of a need to interact with them. We're giving a lot of responsibility to them, and we will expect them to sort of have a point person at the employer who can respond to questions we have. So essentially, we're saying if there's any changes to their contacts, they should make those changes within their CTPL portal within 31 days. The comment was that 31 days is not sufficient time to provide the person who's responsible for it and consider expanding to 90 days. We felt that 90 days is probably too long. One thing we wanted to make clear is this is really just somebody at the employer whom we can reach out to. We can, share information about their plan or request. They don't need to know everything about the plan. They don't need to be the point person for employees when it comes to filing a claim. It's just somebody that we can send a notice to. We're willing to expand it to 45 days. 45 days is a long time to not have somebody at the employer who we can reach out to. When it comes to private plans, we may need to send them requests for the annual report. We may perform an audit. They may be selected for an audit. We'll need somebody at the employer to be able to receive that notice of the audit. When plans are expiring, we send a notice about 6 months prior to the expiration date to say, your plan's expiring, here are some steps you need to do if you want to come back to the public program or renew your private plan. to not have a contact to receive those messages would be, really bad for the employer. 45 days is about as long as I think we're willing to have someone not be listed. We'd love for them to never have a period of time without at least one person at the contact. So we did update that, but otherwise made it clear that really this is just somebody at the employer whom we can reach out to with any questions, requests, or concerns about their private plan. Any questions about that item?
No.
Okay, perfect. The next item is related to penalties. We sort of restructured our penalty section and added language that said employers prohibited from collecting contributions from uncovered employees to pay any penalties. The comment was about this potential that's confusing, as if they can collect retroactively to pay contributions and/or benefits. I think it's the fact that I referred to it as contributions in the original policy, which wasn't the intent. Really wanted to make it clear this is only applying to penalties. So we made the language clearer to say that the employer is responsible for the payment of any penalties. The employer is prohibited from withholding from covered employees' wages or otherwise collecting funds from covered employees in order to pay any penalties. The penalty is the responsibility of the employer. Employees should not be responsible for those payments. So we did update the language to make it clear we aren't talking about contributions. That's a separate topic. This is really just penalties, and particularly penalties related to private plans. One more item related to subrogation. This is in the policy guidance. We indicated that subrogation is limited to benefits which impact the paid leave benefit, and the question from the public was asked to explain what the sentence means. I mean, in a technical legal sense, is confusing and likely to be misapplied. I agree it could be confusing. So for sort of background, subrogation is the idea of I sue on another person's behalf in order to get money from a third party, but really that money was going to be for my benefit. The example I like to use is if I'm standing in my neighbor's driveway and my neighbor, accidentally drives their car and rolls over my foot and breaks my foot, I can't work for 2 months. And maybe I'm out of income for that 2 months. I could sue my neighbor, particularly if there's negligence or an intentional act on his part, and get lost income for my neighbor to pay for the fact that I'm not working for 2 months. But maybe I like my neighbor and I don't want to sue them. I don't want them to be harmed by it. And I have this insurance policy that will pay me lost wages, a short-term disability plan, CTPL plan, whatever it is. So I'll just go to them and collect the money from them. I get income replaced. My neighbor's not out any money. Everyone's happy. Now the insurance company may say, well, hold on a second. Had you sued your neighbor, who was really the responsible party in this, and gotten lost income from them, I wouldn't need to pay anything, or I would pay much less. So subrogation is the idea that the insurance company can sue your neighbor on your behalf, because really it's for their benefit. You as the injured party may not have any difference. It's just where the money's coming from. For CTPL, this really isn't impactful. Connecticut paid leave doesn't really take into account what your neighbor might pay you. There's only a couple of categories of benefits that would impact your paid leave benefit. There's the Social Security, workers' comp, UI, the government programs that can potentially reduce the benefit for paid leave. And then there's the employer provided benefits, the vacation, PTO, sick pay, and maybe the employer short-term disability plan. And that would only potentially impact your benefit, depending on how much you receive and whether it would cost you to go over 100% of your regular wages. So it doesn't have much impact. The neighbor paying you lost income would not impact your CTPL benefit. You could potentially get more than your regular income if your neighbor pays you some for lost wages and you get CTPL. So what happens though is short-term disability or other plans may have a broader category of benefits they can include, and maybe short-term disability can reduce their benefit based on that neighbor example if your neighbor paid you for lost income. Courts, depending on the jurisdiction, are sort of all over the place about whether they like subrogation or are okay with it or dislike it. It tends to add more court cases. So some courts say we don't like this. The injured party doesn't want to sue. We don't want to allow you to sue on their behalf. But other states are okay. Essentially, what we wanted to avoid happening is that our plan is like a foot in the door to get around those laws. We, I think, are indifferent. We think it's up to the legislature and courts to decide whether subrogation is allowed. And if they put any restrictions on it for short-term disability, we don't want to have our program sort of be a way to get around that. So we essentially are saying that these policies grant no right to subrogation that's unrelated to the impact of the plan. As it's sort of way too much of an explanation for such a small thing. But we just want to make sure that we're not providing a loophole to get around any sort of other state or federal restrictions in courts around subrogation. I know I just talked for a while about subrogation. Any questions about that or about the language or any concerns about including it in our policies?
Any questions or comments for Michael? Michael, all we're saying is we're not creating a subrogation right in our law.
Exactly.
That's all we're saying.
Yep.
Okay.
Would the language simply stop there then? Shall not provide a right of subrogation, period?
We can do that. One of the things I worried about is, well, not worried about. I didn't want to change any existing sort of rules. And if a state or a court is okay with subrogation related to paid leave, I didn't want to change that, but we certainly could, because this is our program at this point. But I'm curious if the committee thinks that we should do that.
Have we had any subrogation claims in the last year and a half?
Nothing that we're aware of. It's sort of, if they happen, it would be sort of a private plan, maybe the insurance company of the private plan suing a third party on behalf of an employee. So we wouldn't necessarily be involved in that case, so we might not be aware that it's happening. I don't think it's very common, particularly for these benefits. They're relatively small, like the dollar amount is relatively low, and the court case may not make it worth it. But if it's sort of attached to long-term disability or something that's paid out over a longer period of time, it could have been a part of a larger lawsuit.
I'm concerned
Okay.
that the extra language makes it sound like it does create a right of subrogation to paid leave benefits. Because it says we're only not providing a right to benefits that do not impact paid leave. So it kind of opens that door. I would suggest we just leave it at shall not provide a right of subrogation. The policy itself does not provide a right of subrogation. It doesn't make any assertions as to whether the law does. And it might just be cleaner.
That sounds good to me.
I can
Can
change that. Oh, go ahead.
Can I just ask a question because to be frank, just taking in the information on subrogation now, I need to just reorient myself. If an individual, when there's concurrent benefits, if we preclude somebody from, well, I guess remind me the order of benefit receipt on behalf of the employee.
It depends on what.
Okay. But there could be instances where there's concurrent receipt, right?
Yes.
Right.
So I'm sorry, can I just like talk out the logic for a second to get to my question? So in an instance where an individual is receiving benefits concurrently, if we preclude them, if we don't allow subrogation, right, then are we precluding like a complete remedy in the situation? Like, are we going to have this issue where we're like one of these who's on first situations if someone's receiving benefits concurrently? Does that make sense? My question?
It does, but I think if I'm understanding your question correctly, you're concerned about the individual in Michael's example who had his foot run over, being able to piece together benefits to make sure that they're made whole. The subrogation is not the individual's right, it's the insurance company's right.
Well,
So
yes. Sorry, Erin, I didn't mean to interrupt you.
yeah, so I don't think we're doing anything that would harm an individual from putting together benefits to make whole. We're basically saying the insurance company can't stand in the shoes, sorry, but stand in the place of this individual, kind of overriding the individual's own decision and, you know, sue the neighbor's homeowner's insurance so that they don't have to pay, or that they're not out the money that they paid under the private plan.
So I understand that piece. Can I just take it a step further, but flip our point of reference, right?
Yep.
If we preclude subrogation from, are we setting a precedent that we then couldn't go after any carrier or whatever where we're paying something that we shouldn't be paying? Does that make sense? Or is that just irrelevant in this space? I guess I just need to take it I need to take my mind full circle on this.
Yeah, I think it potentially, I don't know if we would ever do this. I don't even know if we have a legal option to do this, but it would stop us from forcing a carrier to pay a benefit that the employee never provided, or forcing somebody else, a third party, to pay a benefit that the claimants never asked for, by us standing in the shoes of the claimant. So far, our policy has been, we don't force you to apply for any benefits that you don't want to apply for. If you do apply for benefits that impact the CTPL claim, we may take that into account and reduce or potentially deny your claim. But we're not, in order to save us money, we have not been reaching out and forcing people to apply or applying on their behalf to other programs.
Okay, I'm sorry to belabor this, but now I have just one last question and then I'll leave it be. In the instance that an individual has a workplace injury for which they have not proven their workers' comp claim, and they're pivoting and have a valid claim or determined to have a valid claim under paid leave, does this in any way muddle that process by not allowing the parties to, or the carriers or whomever, to take full responsibility for their liability?
This should not muddle the process. It only sort of prevents us from inserting ourselves into that process, or a
Okay.
private plan inserting themselves into that process. The way the currently works under the public program, at least, is if you've applied for but not yet had a full adjudication of your workers' comp claim or other claim, we will move forward with processing the claim. If it turns out you are later approved and then those benefits apply to the same period of time that you were approved for paid leave, it would now become an overpayment. But we are not going to hold up the process or force you to take any different action in the process in order to reduce our liability up front.
Okay. Yes, it does. All right. I appreciate you entertaining my thought process. Thank you very much.
Thank you for those questions.
Any other questions, comments? I have a question for you, Mike.
Sure.
Not to belabor this, but what would be the downside if we don't address this at all? I mean, it causes confusion. I'm not sure why we should be involved one way or the other in the relationship between the two neighbors and the insurance carrier, in your example. I mean, why not just eliminate this? Just delete it.
Good question. It's I think it's a small risk, but what I wanted to avoid have happen is, so particularly with employers who are located in various states, they may have their headquarters in, let's say, Massachusetts, but they have employees in Connecticut who are getting CTPL benefits. And maybe I'm making this up, but maybe Massachusetts takes a hard line about subrogation. They don't like it at all. Their short-term disability policy may be a Massachusetts policy that has to follow Massachusetts rules. And so they couldn't get subrogation in their Massachusetts short-term disability policy. So maybe a clever lawyer says, well, we can't subrogate for short-term disability, but this employee is in Connecticut. There's this other policy that also has liability. Let's use that and force them to subrogate. And once they subrogate to sue the third party, now those benefits can be helpful on the short-term disability side. We basically don't want our program to become a tool to get around other laws. So that's the reason why we added it. But to your point, I don't think it's happening very often. I don't think it's a very common thing. If we feel like it adds more confusion than it helps, I think we can explore removing it.
I would say though, part of the promise of the private plan is that the employees get equal or better benefits to our state program. And since we don't require employees to sue their neighbor, and we're not going to try and assert a subrogation claim. If we were to allow private plans to do so, the employee ends up getting less in that situation. And so there is an argument that if we don't close the loophole, we are allowing private plans to craft language that results in employees getting a lesser benefit than they'd get under the public program.
Well, help me understand that, because I thought the employee is going to get whatever benefit the private plan provides, and it's only the, let's say, the company or the insurance carrier or whoever's funding the benefit is suing the neighbor. But the employee's benefit is not affected.
I could be misstating it then. I guess
know.
I think that's a fair point, and I'm not sure if I should withdraw my argument. I have to think about that a little bit.
And I will say, we're talking about legal actions. They can take years. I think one of the things we would want to avoid happening is saying, well, we're not going to pay your CTPL benefit because, and I'm thinking about a private plan now, because you have this other person responsible, we'll wait till that outcome is kind of resolved, or that action is resolved, and then kind of figure out what the calculation is after the litigation is resolved, because that could be a significant period of time where you're out of that income. So you certainly would have a gap in timing for getting paid CTPL benefits.
I didn't realize a private plan can do that. I thought their plan had to pay the benefit, is required to pay the same or better benefit that the authority provides. If there's the likelihood that they could delay payment until resolution of any litigation, I think that's a problem, right? Because we don't want that.
I think it's debatable
I'm not
whether
sure
you're
this
allowed to do that.
language addresses that.
Yeah. It's certainly not something we anticipate. It's not something we would want to have happen. I think there's a question about whether an insurance company or employer could say that, they're not responsible because somebody else is. Therefore, they're not going to fully adjudicate the claim until that's resolved. I certainly don't want that to become standard, or I don't think that's something we would want to encourage or say they have the right to do. But I also don't want anyone to misread not having language as giving them that power.
I'm thinking maybe we take the time in this week for, I'm going to say Joe, to do some research and maybe kind of either analyze the likelihood of whether the proposed language prevents the outcomes we're trying to prevent. And then maybe we have, because these are really good thoughts that I think we need to vet more. We can come back next week with either a recommendation that yes, the language addresses the concern, no, the language doesn't address the concern and here's different language, or it's not really a concern and we can leave it out. Would that be a good approach? Because I think we need to do a little bit more research.
Yeah, that sounds appropriate to me. Anybody else on the committee have any thoughts?
I think that sounds great. Appreciate that.
This was really helpful. This was a really good discussion to help us make sure we are thinking through all the parameters.
Thank you very much. And any other questions that the committee has about any of the other topics? We're wrapping up this subject.
I just had one process question, both on this issue and the one before. I think you mentioned you've gotten a request or two for a copy.
Mhm.
Isn't the copy publicly available? I mean, when we, I'm wondering why people are asking for copies if it's on our website.
Yes, great question. When it's the small change, like a change to a sentence or a paragraph, we can post that whole change in the Connecticut Law Journal. But for something like this or the Finance and Accounting Manual, which are 30 pages or longer, the journal doesn't want to have to publish the entire thing in the for the public comment. So instead, there's a notice about, we're making changes. If you'd like to receive a copy of those changes, please reach out to Michael Caesar at the authority for that. So it's sort of trying to accommodate the law journal's space requirements.
So there's no reference to a link that law journal readers could go to see.
No, it's just they have to ask for it.
All right. I'm sorry for even taking the time. Just try to understand that.
No, it's a great question, and I wish there were more people in the public at this meeting so they'd be aware that that's an option. I worry a little bit that people see the notice and feel intimidated to reach out to me and ask for it. I'm a very nice person. I will give it to you immediately. I promise.
With our new website, we have a little bit more flexibility. So one of the things I want to do is be able to actually post our changes sort of on our own space. It doesn't meet the legal requirements of posting in the Law Journal. We'll continue to do that, but I would like to use our greater flexibility with the new website to add another source of information, because the Law Journal is terrific, but they do have space concerns and formatting concerns. So, for example, with the finance, all of the charts and tables, they can't actually replicate in the journal. So what we end up doing is try to provide a pretty detailed summary of the proposed changes so people have an awareness of what the changes are likely to include. If they want to get a copy, they can, but we'll try and I'd like to do more with the new website.
Okay. Any further thoughts or comments on the private plan policy revisions? Okay, hearing none. Any old business anyone wants to raise? Okay, moving on. Any new business anyone would like to raise? Hearing none, moving to adjournment. May I have a motion to adjourn?
I'll move the motion.
Thank you, Eva. Second?
Second.
Okay, all in favor? Aye?
Aye.
Opposed? Abstentions? The motion carries. The meeting is adjourned. It is 9:34. Thank you very much for your time this morning. Enjoy the
Thank you,
beautiful
everyone.
day.
Thank you. Bye.
Bye.
Bye-bye.